Senate Republicans have made history by confirming Justice Amy Coney Barrett to the Supreme Court. The 52-48 vote was mainly along party lines, with only one Republican, Susan Collins of Maine, voting against. Barrett was sworn in by Justice Thomas last night and received the judicial swearing in today by Chief Justice Roberts. Her confirmation is the first this close to a presidential election. It is also the first vote in modern political history to garner zero support from the minority party. Already, Justice Barrett is looking ahead to her new position.
My fellow Americans, even though we judges don't face elections, we still work for you. It is your Constitution that establishes the rule of law and the judicial independence that is so central to it. The oath that I have solemnly taken tonight means at its core that I will do my job without any fear or favor, and that I will do so independently of both the political branches and of my own preferences.
It is highly fitting that Justice Barrett fills the seat of a true pioneer for women, Justice Ruth Bader Ginsburg. Tonight, Justice Barrett becomes not only the fifth woman to serve on our nation's highest court, but the very first mother of school-aged children to become a Supreme Court justice. Very important. Throughout her entire confirmation, her impeccable credentials were unquestioned, unchallenged, and obvious to all.
And for more on this, I want to bring in Mark Chenoweth. He is the executive director for the new Civil Liberties Alliance. He was also chief of staff for Secretary Mike Pompeo when he represented Kansas's 4th District. Mark, welcome. Thank you so much for being with us. Can you give us a preview of the cases coming up on the Supreme Court's docket for the rest of the year that Justice Amy Coney Barrett may play a role in, and how you see her shaping the court's opinion on them?
Well, there are a few cases that folks have talked about with specific regard to Justice Barrett joining the court, and perhaps the one most talked about is the upcoming Obamacare case. And Texas v. California is the name of that case, although there are a couple of cases tied together there. And in terms of how her participation will affect that, obviously it remains to be seen. But the thought is that because she has told the Senate that she is a textualist, that she will be drawn to applying the text of the Affordable Care Act as Congress passed it, and that will include. There's a dispute over whether or not the rest of the statute can still stand once the individual mandate was stripped out of it by Congress. And there's a provision in the statute that calls for severing any part of the statute that calls for allowing the rest of the statute to stand if part of it is severed. But it's up to the court to figure out whether that can still survive the constitutional analysis that the statute received before. So that's one important case that she'll be looking at. Another one is Fulton v. City of Philadelphia. The issue there, and I believe that's being argued on Election Day, but the issue there is that the City of Philadelphia has prohibited Catholic social services from participating in the foster care program. The Catholic social services have been involved for decades in the City of Philadelphia with foster care placements. But they have been unwilling in recent years to place foster children with same-sex couples. And when same-sex couples come to them, they refer them to other foster care placement agencies in the city. But the City of Philadelphia has said that accommodation is not okay with them, and they wanted to exclude Catholic social services from the program. And so the agency has sued, and now we'll see. The Supreme Court will decide who is right under the First Amendment in that case. A third case that is going to be decided this year is Collins v. Mnuchin. This is a case that came up from the Fifth Circuit involving the Federal Housing Finance Agency. The Supreme Court this past summer in a case called Saylor Law decided that having a single director of a federal agency, in that case it was the Consumer Financial Protection Bureau, it was unconstitutional to have a single director if that person was protected from removal by the president with for-cause removal protection. And the same exact situation exists at the Federal Housing Finance Agency. And so it would be a little bit surprising if the court did something different in that case than what it did in Saylor Law. But it's slightly different, and so we'll see whether the court strikes down that agency's situation as well, or whether they will sever the for-cause protection that the head of the Federal Housing Agency has.
It's interesting, the second case you mentioned there, the one regarding foster care in Philadelphia, will be heard on Election Day, because my next question involves Election Day back in 2000, where we saw the fate of the presidential election fall into the hands of the Supreme Court. So given the unconventional year that has been 2020 and all the oddities it has created for this election, such as massive early voting, do you see the possibility of this happening again?
Well, there's always a possibility that something like that could happen. I don't think it would be exactly the same situation. The issue in Bush v. Gore had to do with whether or not the recounts were being done in a way that violated the Equal Protection Clause. I'm not sure that exact same situation would present itself. I think it's more likely that something would come up involving the various ways that ballots are being counted or not counted that come in after Election Day. I think that seems to be the likeliest source of controversy to emerge. Hopefully it won't. Hopefully we'll have a smooth Election Day, or the vote will turn out to be not close enough in any state that will make a difference in the outcome of the election, and the court won't be involved. I think that would be better for everyone concerned.
For sure. We would all hope for a smooth Election Day. So compared to the makeup of the Supreme Court now to that during the 2016 election, how do you see President Trump's Supreme Court picks making a lasting impact on the nation's highest court?
Well, it's been a while since we've had a president appoint 3 justices. I think since President Reagan. And if you would look back at, I guess, the 4 justices that President Reagan appointed, Sandra Day O'Connor, Chief Justice Rehnquist was elevated to the Chief Justice position, Justice Scalia, and then Justice Kennedy. I'm not sure that those 4 justices necessarily behaved in the way that President Reagan thought that they would when he appointed them. And justices serve for life. There's a long period of time there, and they're obviously independent judges, or justices in this case. And so what I think will happen is that we'll see a court that is somewhat more, that's adhering more closely to the text of the statutes that Congress passes, and therefore we'll see a reinvigoration of self-government, where if Congress wants to do something, then Congress has to pass that law, rather than either expecting the courts to do the job for them or expecting a federal agency to exceed the power that Congress has given it and then have a federal court approve that sort of executive overreach. So I think it could be a great development if we see that more self-government forcing Congress to do the job that the Constitution expects Congress to do.
All right. Well, Mark Chenoweth, Executive Director for the new Civil Liberties Alliance, thank you so much for joining us.
Thank you for having me.